China was engaging in billions of dollars of theft. In fact, it's one of the largest wealth transfers in human history. Patents are in the Constitution. George Washington was what we would now call an angel investor. The pharmaceutical revolution starts in Germany in the 19th century, but it shifts to the United States, in part because we have a patent system.
Adam Mossoff, professor at the Antonin Scalia Law School at George Mason University. We're going to talk patents today. To what extent patent policy caused the great divergence between the West and China, explore contemporary Chinese IP strategy, a brief history of Biden and intellectual property, looking forward to the different strains of thinking within the Trump universe and how that might play out with respect to patent and innovation policy, and finally explore AI byproduct as well as the AI input side on where patent policy is going to play a role in the future of artificial intelligence. Thanks to the Innovation Alliance for sponsoring this episode. The Innovation Alliance is a coalition of research and development-based technology companies representing innovators, patent owners, and stakeholders who believe in the critical importance of maintaining a strong patent system that supports innovative enterprises of all sizes. Adam, welcome to the podcast.
It's awesome to be here, Jordan. And based upon the introduction, it sounds like we're going to be talking about life, the universe, and everything.
All right. We're going to bring it back to 1787. Why was patent policy so uncontroversial that it got written directly into the Constitution without there even being a debate during the Constitutional Convention in Philadelphia?
Yeah, it's a great question because a lot of people don't realize this, that first of all, patents are in the Constitution. It's the power to secure the exclusive right to both inventors and creators, artists. So they don't use the term patents. They don't use the term copyright. They just say the exclusive right. And inventors and creators is one of the powers delegated to Congress in Article 1, Section 8 of the Constitution. And this is the very first time in human history that the power to protect patents and copyrights, together intellectual property, is in a country's founding document. And there are, I think, a lot of reasons for this. But some of the kind of core central reasons is that that the founders recognized that creators and innovators morally had just as much of a right to the fruits of their productive labors, to this notion from John Locke that we have the right to mix our labor with things in the world, and that's what creates property and that's what you own. That they recognize that this applied to innovators and creators. George Washington was what we would now call an angel investor. He actually was investing in some steamboat inventors at the time in Virginia.
All right, but Adam, what were his returns like?
Apparently not very good, from what I understand. So and even Daniel Webster of Webster's First American Dictionary, he actually traveled to Philadelphia to explain to the delegates at the Constitutional Convention how he was unable to effectively sell copies of what would become his First American Dictionary because of the different types of protections for copyright in the different states that varied from state to state, that he had a book that needed to be sold. Therefore, he needed national protection of his rights. And Robert Folsom of course, steamboat fame actually did a demonstration of some of his early prototypes of his steamboats to the delegates. They actually took a break from the convention and went down to the Delaware River and watched his little prototype. So they were intimately aware of these issues and understood the importance of them, especially to a new country that didn't have an industrial base. It was primarily agrarian at the time still. And that this would be key to the growth of our innovation economy.
Yeah, I mean, honestly, like, if a founding father doesn't have a 20% or return on investment year over year, I don't know why the hell they made it on Mount Rushmore. So many funny things come out of that like origin story, right? I mean, It's like this is downstream, of course, of people being pissed off at England, which is, the first modern country to set up a version of this, but the sort of royal prerogative that was baked into that whole ecosystem of like patents being like at the whim of the crown, and it's like assigned to one person, and like, by the way, the crown never has to pay any royalties. It was a much less comprehensive and sort of more arbitrary, though, better than like whatever they were doing in the Frankish kingdom or what have you.
Yes, right. Yes.
It's a really interesting moment. And so many fascinating echoes. It's like Daniel Webster, the first patent lobbyist. It's like, congratulations, we have a rich legacy here. And then like the inventors like showing up and like trying to like do these tech demos, like the same thing as Sam Altman going to DC the month before GPT-4 comes out and saying like, hey guys, don't regulate me, like support my industry because like I got this cool thing that's going to really matter to America. Some things change, some things don't. Okay, so like we have this policy where the Constitution says that intellectual property is actually property and, should be something that you should be able to make money off. How does that end up like instantiating in the first few decades of the Republic?
Yeah. So, by the way, before I answer your question, I mean, the way you reframed, the origin story is a bunch of lobbyists, lobbying for protection, right? That's sometimes how that's characterized, right? But the founders were really sensitive and aware of, the abuse of government monopolies by the Crown and by England. And so they recognized that these weren't monopolies, right? I mean,
sure.
And in fact, I like to point out that what we now call the copyright and patent clause, the clause that, authorizes Congress to secure the exclusive right to inventors and creators for a limited time, that's the only place in the Constitution before the Bill of Rights where you'll even find the word right used. So when they're using this term exclusive right, as you mentioned, they don't use the term property, but they say exclusive right. That means property right. And this was the key going forward, is that then President Washington, in his first address to the very first Congress, calls upon Congress, in his address to enact a copyright and patent statutes. I mean, and they do it. It's the Patent Act of 1790, the Copyright Act of 1790. These are some of the very first pieces of legislation Congress enacts because they recognize this as fundamental, not just to the economic growth of our country, but fundamental to protecting property rights as such. And that's what they secured them as, not as these kind of, as you mentioned, these kind of royal grants, these gifts from the Crown, but that these were property rights. And what that meant was that they could go out into the market with them and transact with them and commercialize them the way that we think of people commercializing their property rights now, the way you can sell your house, or you can sell your computer, or you can sell a portion of something, or you can rent a car, or someone could rent a room in their home, or buy a building and rent it out to tenants and things of this sort. And that's what inventors immediately started doing. They immediately started to engage in what we now call licensing. I can invent, but I don't have to manufacture. I can actually engage with you as the manufacturer, and we can therefore divide our labor and specialize. And I'm really good at invention, and you may be really good at manufacturing, and so you go manufacture, and then and split up, by the way, your manufacturing into different places and different retailers and sellers. And in fact, patent owners invented what we now call the franchise business model, which is an intellectual property licensing business model. We associate that with fast food, like, oh, franchises, that's like McDonald's or Wendy's. But actually it's actually an intellectual property licensing business model where the person who owns the IP licenses to other people to manufacture and run and sell the products. And this is what Samuel Morse did when he invented the telegraph, the first electromagnetic successful telegraph. And of course, the code that goes with it that we know is Morse code, the dots and dashes. It's what Charles Goodyear does when he invents rubber. He has no affiliation with the Goodyear Tire and Rubber Company. That company was actually created 40 years after he died. It precipitated a trademark lawsuit with his family over the use of his name, because he was just this crazy inventor. He was an insane crazy inventor. He wrote a 2-volume book on all the cool things you could do with rubber, which is just for pages lists, like you can make boats out of it, you can make shoes out of it, and then to prove his point, he had many copies of it bound in rubber. So he didn't want to manufacture. He licensed other people to do it, and that was exactly what you would want him to do. And this is what then quickly distributed these products more efficiently into the marketplace, spread them more quickly, got people engaged in a lot more commercial activities, and it brought a lot more people into the system. It democratized the invention, it democratized our commercial processes, and it's what led to this explosion in new products and services from the United States in the first 50 or 60 years of its creation.
Yeah, so let's just underline that for a second. The British model was A, the crown gets to decide, and B, if you get the patent, you have to be the one to make the business to sell it. And the problem is, like, there are not that many, well, Elon Musk, we'll get to him later, but like there are not that many sort of engineering geniuses or, tinkerers, as the case may be, county, clerics and what have you, who also have this sort of like rapacious capitalism gene in them to sort of like go out and build factories and empires and sales teams and whatnot. In the late 18th and into the early 19th century, what the American model allowed is for you to still get rich and be able to sort of like translate your invention, or I guess spread your invention across the country and economy more broadly, by not having to be blessed both with the sort of engineering genius as well as the business genius.
Perfectly stated, and Abraham Lincoln famously identified the U.S. patent system as actually one of the three great achievements in human history, the first being language and the second being the written Constitution.
He was a funny guy, Adam. Let's be,
Yes, but he said about the patent system, he said it added the fuel of interest to the fire of genius, which is just this really eloquently, beautifully stated statement, right? That captured perfectly what you just said. And by the way, Lincoln knew of which he spoke because he's actually the only U.S. president to have actually received a patent too for an invention that he came up with. Not while he was president. He actually invented something in 1848 before he became president.
What was it?
It was a method for lifting boats over sandbars and other types of obstructions in the Mississippi River. And it's unclear whether it was actually deployed or not, and whether he actually made any money or not. He did work as a lawyer, actually representing other patent people when he was a lawyer in Illinois. He represented, for instance, Cyrus McCormick, who invented the mechanized reaper, which was the very first true labor-saving device in human history. I mean, the efficiency for food production. This is why Malthus was proved wrong, because the food production went massively through the roof after the invention of the mechanized reaper, and he represented McCormick in a lot of his lawsuits against infringers of his reaper. So he knew the patent system very well.
All right. So again, coming out of paternity leave, of course, all I did was read Civil War history. So there's this like incredible moment, just like, example 574, why Lincoln is an incredible person. So he got onto this McCormick case, which was going to be the biggest case of his career. I think it was in St. Louis, so he had to take a boat or whatever and got there. And then all of a sudden McCormick was maybe we should bring in some big guns from the East Coast who actually had gone to law school. So Seward shows up, who's like the hottest lawyer on the planet. He literally takes one look at Lincoln, who is like gangly and has, tattered clothes on, and he has this messy 400-page brief that he's prepared. And Seward does not talk to, basically, literally, I think, does not talk to him over the course of the entire case. And it's just incredibly rude, incredibly disrespectful. And sort of Lincoln's what he took from that experience was not resentment, but oh my God, I now know what it's like to play in the big leagues. I got to go back and I got to up my game. And I'm so thankful for this opportunity to have, been the equivalent of a pinch hitter who never gets subbed in on a World Series baseball team. And the fact that, from that experience to appointing this guy as your Secretary of State 15 years later, it just shows this sort of incredible magnanimity of Lincoln. He gets to be on Mount Rushmore, even though he didn't make money from his patent. I'll give him a pass.
Well, those people, their ROI is, we have a country. We have an amazing country that survives incredibly amazing ups and downs, right?
Yeah, he gets credit for all the GDP post 1865. Okay.
Yeah, I mean, he saved the Union, kind of a small thing.
But I do want to come back to this line that you had of Lincoln of say it again, the fire and genius.
The patent system added the fuel of interest to the fire of genius.
Okay, so we did an epic 4-hour 2-part show with Yasheng Huang, which came out over the course, I guess, like a few months ago. And one of the key mistakes that Professor Huang argues, like Chinese civilization made, is that the importance of the exam system starting in the 700s basically like stripped out all of the sort of economic returns and like class, like esteem returns from doing inventions. And what's really remarkable about what the United Kingdom and the U.S. did at the in the start and the continuation of the Industrial Revolution is like they figured out how to let people make a lot of money and get rich and famous, and have people write nice things about you by doing science, which was like not something that happened for basically all of human history before then.
Mm-hmm. Yeah. So it's a fascinating phenomenon. It's been written on, and I'm sure your show has covered it many times in the past, of how China was incredibly inventive, right? I mean, they invent paper money, they invent gunpowder, they invent, they had one of the first modern, massive fleet ships, incredible ship technologies, the abacus, and I mean, so many things China invented first, right? But then invention shifts to the West, to Europe and to the United States eventually, and innovation in particular shifts to the United States, and to the West. And that's a distinction that we have today now, is we distinguish now between invention and innovation. Because humans are naturally inventive. Humans invent for all sorts of interesting reasons, and prestige, personal interest, joy, but inventing something in your lab or in a garage is not the same thing as the innovation that is actually used by everyone, especially consumers, right? And is mass produced and deployed in the marketplace and is sold through stores or over the internet now. And so that was kind of the key feature in the United States in recognizing that patents are property rights, and which serves as both direct financial interest, but also serves a democratization function, because anyone can invent and anyone can then get this property right in the same way that anyone can be a farmer or anyone can be a worker and anyone can be a podcaster. And, if they wish to choose that career, and then the property right serves as the basis to enter into all the contracts and enter into all of the deals, to commercialize, to engage with manufacturers and others, to create, for which you get the profit and the benefit from, and consumers get the product that's ultimately sold in the marketplace.
There is this like American national stereotype, like a nation of pioneers, like self-willed, whatever, like go out and do your own thing. And, the sort of UK stereotype is like, the British Academy of Sciences, which is like a little more centralized and like,
yes,
in the early years of the Industrial Revolution, you did have this very distributed, like, some guy in a county parishioner, like inventing something, but like pretty quickly you start to have this a more aggressive sort of like caste system and hierarchy when it comes to science. I'm curious for your take on the sort of like, is it really nature versus nurture, like institutions versus like national character? When it comes to the American story of sort of like engineering-based businesses in early U.S. history.
It's a great question, and and there's a tendency to want to be reductionist about things and to say, oh, it's all this one thing. It's like nature or nurture. Why can't it be both? And so I think it's more of a symbiotic relationship here between we have these very strong intellectual and cultural norms and ideals in our society about individualism, about individuals being able to pull themselves up by their bootstraps, as they used to say in the 19th century, and there's lots of examples of that, and the freedom and ability to obtain property rights in the products of your labors including inventive labors, was a key part of that, right? So a lot of the people that I've been talking about, Goodyear, Cyrus McCormick, even, Samuel Morse was a professor of art at NYU when he invents the electromagnetic telegraph. Samuel Colt whittled, he was a shipmate when he whittled his first wooden version of his repeating firearm, the Colt revolver. This is Dr. Leo Baekeland, who was a very well-established, famous chemist in Europe in the late 19th century. But he cared very much about the practical application of his discoveries and work in chemistry. And so he actually immigrates to the United States and continues his experimentations in chemistry. And the thing that makes Dr. Baekeland so famous is he's the inventor of synthetic plastic, which he gets a patent for in, I think, 1906, and then trademarks under his name, and it's why early plastic is called Bakelite. Elias Howe, who invents the lock stitch, which is the key technological feature of the sewing machine. He was so destitute, he had no formal schooling, that when he discovered Isaac Singer was infringing his patent and selling the famous Singer sewing machine as we now know it, he actually had to get an investor to fund his lawsuit because he actually had to sell an interest in he sold a security interest in his patent as a property interest to fund his lawsuit. These were not people who were aristocrats. They didn't come from, highbrow society. They weren't rich. They weren't socially privileged. And they became very successful, and many of them became household names through this system of property rights, through these norms. So it's a combination of the law reinforcing and supporting the cultural norms, and the cultural norms reinforcing or driving the reason why we have those laws in the first place.
And if folks are interested in this, I would highly recommend the book From Know-How to Nowhere, The Development of American Technology by Elting Morrison. Came out in 1977. If people recommend books to you that were published in the 70s, they're good. In particular, I think he does an awesome job of there's sort of all this railroad innovation and canal innovation that happened, as well as the sort of early years of MIT and how it was very much like a trade school. And, it was, the contrast was with Harvard and everyone who had their doctorates, who was, who had this gentlemanly aesthetic of we don't want to be anything near the market. The professors at MIT all had companies. They were all doing consulting for the railroads and the steamship firms and what have you. And by getting the thesis of the book basically was by having this sort of engineering culture and having the sort of most prominent institution, I guess, after West Point, be this aggressive, be very much engaged in the commercial markets. You ended up sort of bleeding the sort of invention to innovation translation function much more into the bloodstream of the types of people who are going to end up being excited and doing this stuff in the first place.
So Americans, in addition to kind of having these norms of individualism and respect for property rights have been from the get-go very practically oriented, very real world problem set oriented. In fact, one of the people who first kind of notes this is Tocqueville, who writes this book called Democracy in America. Tocqueville basically, does what we would now call a fact-finding mission. So he was an aristocrat in Europe, and Europe was really, they were befuddled by America. What is this country, and what are they doing, and how are they becoming so successful? Because we've all seen Hamilton, right? Where the song, "You'll Be Back," after the Revolution. They really did think that. They really did think that we were like teenagers. We're this upstart, know-it-all little new country. And, we didn't really know what it would be like. And we would eventually come begging to be readmitted back into the Commonwealth. And, 60 years after our revolution, right, we're marveling the world at the very first World's Fair, the 1851 Crystal Palace Exposition, with all of the new innovations coming from our country. Rubber and sewing machine and the telegraph and the mechanized reaper and so many other things. And so they were really befuddled by us. And so Tocqueville kind of does this, he goes on his fact-finding mission. And one of the things he keeps noting is how, our term now would be pragmatic, how practically oriented we are. like everyone's kind of thinking about kind of like, well, what's the practical application of this point? Like in my life, and not just practical application, but in my life, like what can I do with this to make my life better, to make me happier, to make everyone else better off as well. And this really becomes kind of this is a kind of has long been a key feature, and our patent system and property rights more generally serve this what's been called the democratization of invention idea. That this a phrase is coined by Dr. Rosina Khan, an economist who has studied the history of patent systems and innovation, and and I think she's exactly right that viewing redefining patents from these privilege grants from the crown into property rights serve this function of making them accessible and to everyone. And it keyed into this kind of norm in our culture of being very practically oriented, of being very individualistic. And it fed the whole explosion in economic growth. It's why the Industrial Revolution shifts to the United States in the 19th century. It starts in England, even with their kind of nascent patent system. It starts in England, we all know, with James Watt's invention of the steam engine and other innovations. But then it shifts to the United States. The pharmaceutical revolution starts in Germany in the 19th century, but it shifts to the United States by the early 20th century, in part because we have a patent system where you can get protections and deploy these products in the marketplace. And then by the mid-20th century, the revolutions in technology and science are no longer just happening in other places. They're now happening in the United States, and they're intimately bound up with the patent system. The computer revolution, the internet revolution, the biotech revolution, and now the mobile revolution.
Awesome. All right. Well, so we're just going to jump to 2020. What were the sort of key developments over the past few years, both from well, let's start with a Biden administration perspective, and then we'll look to global actors.
Well, I would actually go back a little further than 2020. I'd go back to about 2006 or 2005. So past 20 years or so. And in the past, and so so we have largely shifted over the past 20 years from providing kind of very effective and reliable protections for patent rights in this country to destabilizing patents as property rights. So we made it much harder to obtain patents, much harder to keep patents, that they can be easily validated or the term is canceled by this administrative agency now at the Patent Office called, it goes by the acronym PTAB, Patent Trial and Appeal Board, where they have like cancellation rates of 80%, 85%. At one point in time, one of the programs, it was 100%. It's become very difficult, therefore, to retain patents. It's been very hard to stop infringers from stealing your inventions, stealing your patents. You can't get injunctions anymore. Damages have been reduced significantly. And there's just been this kind of narrative that has been developed, it has been pushed by companies and other interested parties that, patents are, obstruction to innovation and undermine the innovation economy and things of this sort. And so it's kind of created for all intents and purposes, almost a moral panic at times about the patent system in Washington, D.C. And so this has been a radical sea change from kind of what generally the United States did in the years preceding that.
So Adam, I want you to give the arguments in favor of the new paradigm you just laid out.
Okay, the Steelman arguments for why the changes had to be made to the patent system is that that today's technology is different than technology from before. Things move faster. It's more complicated. There are more ways and reasons why people would invent new technologies other than just the motivations provided by the patent system. And so yes, you might need some patents for some limited types of innovations potentially, like the drugs, because one has to spend years to investing in the creation of new drugs. But for most other products and services, the internet makes it easy, makes it possible for people to get, just to become famous and to sell products and services and things of this sort. And you can get first mover advantage and other types of justifications for for succeeding in the marketplace now. So patents actually aren't just necessary; they obstruct people because then other people use patents to stop people from doing those types of things.
So I think this is a good place to bring in Elon, perhaps the only person on the planet who can tweet something about patents and get 100,000 likes for it. Just a few weeks ago, he said that, so Tesla and SpaceX famously are patent shy and patented basically nothing. And he tweeted, only patents for things that are super expensive to prove work, but are then easy to manufacture, like stage 3 drug trials, have any merit. What's your take on that line of thinking?
Yeah. So Elon by the way, has been a longtime skeptic of patent rights. He has, tweeted at times that we don't even need a patent system at all. And he has talked about, patents as not being necessary in any way, shape, or form. So this is actually an improvement on his part, that tweet. He's gone soft on patents since, at least into his opposition to patents. I mean, well over 10 or 15 years ago, he announced that Tesla was giving away all its patents in a blog post at that time that where he turned the phrase, all your patents belong to us. It was a turn of phrase from the first Iraq War, where the spokesman for the Iraq government, this is back in the early 90s, said all your bases belong to us, when he was saying the United States, we're winning, we're beating the U.S. and people were like, the U.S. has got bases and they're everywhere and the tanks are right outside this press conference, and he said all your bases belong to us. So did a blog post called "All Your Patents Belong to Us." But so it's actually not true that Tesla doesn't have patents. Tesla actually has a ton of patents. They have design patents on the Tesla cars. I actually tweet about those at times. They actually have a ton of patents on their battery technology because their batteries are actually incredibly revolutionary. And in fact, that announcement even 15 years ago when he said anyone can use our patents, that was actually not true. And I actually did a response op-ed where I talked about how actually his blog announcement was not actually what the Tesla policy was. The Tesla policy was actually a cross-licensing proposal. It was, if you use any of our patents, we get access to all of your patents.
Wow.
But also, one of the reasons why they wanted people to be building cars is because they had the key technology for the batteries that would be used in all electrical charged cars. And so they wanted to get as many people having to buy their batteries because they had the manufacturing capability set up for it. So again, it was a use of their patent rights. They were exercising their patent rights. They were saying you can have access to our patents because that's what we get to choose as property owners, and we get access to your patents if you do choose to use our patents. And we want you to build lots of cars because we have these cool technologies that we've acquired and licensed and built through patents, through our property rights, that we get the benefit from as well. So, but his more recent statement about patents on, you only need patents for things that, have initial high upfront costs that are easy to copy. It shows a real misunderstanding of patents. Again, it shows that people have this mode of thinking of patents going back to the original English Crown privilege monopoly grant, that I want to incentivize someone to invent something or to create something from the get-go. And so I promise a monopoly to them in exchange for that, for them to make the initial investments to create it. And that is a function of patents. It's a function of property rights more generally, that they incentivize people to create and invent and to produce. But that is not what patents do as property rights, because as property rights, then they do so much more on the back end, which is that they facilitate the commercialization, the deployment, the licensing. Even in the biopharmaceuticals sector, where people think of these drug manufacturers as big monopolies, is like, oh, well, Merck invents the drug and then they manufacture the drug. It's actually not true. There's massive cross-licensing deals and information sharing deals over the patented technologies and the patented drugs in the biopharmaceutical space. And this is what made it possible for the pharmaceutical sector to have its revolutionary response to the COVID pandemic, because they had all of these licensing deals and all of these incredible manufacturing cross-licensing agreements they were able to exploit and to create and enter into to quickly respond to the pandemic by massively increasing manufacturing capabilities and commercial distribution of the vaccine. So at a certain level, it reflects just a misunderstanding of what patents do. There's not about incentivizing people to actually make the initial investments, although that is one function. Patents as property rights also facilitate the commercialization. And we always, in this sense, patents are no different than any other property right. All property rights facilitate commercialization, and that's what patents do for new technologies.
Let's talk. Okay, so we have the Elon strain of Trump 2 thinking. What other what else is in the Trump world soup when it comes to ideas around the future of patent policy?
Yeah, so Trump himself, relies on intellectual property, trademarks. He puts his name on everything, his hotels and steaks and wine and everything. He doesn't rely on patents as much, but he does rely on, trademarks, which is a type of intellectual property. Usually we think of intellectual property, people think of patents, but it's a broader range of different types of intellectual property. We always have to remember that. And in his first administration, Trump was actually, very supportive of especially reliable and effective patent rights. Through his administrative officials that he had in his first Trump administration. So Andrei Iancu, the director of the patent office in the first Trump administration, understood the importance of reliable and effective patent rights, and since 2020 has been an advocate on behalf of them. So it potentially could recreate that approach again, and we could see a kind of a more a return back to an emphasis on having reliable and effective patent rights, kind of changing course, reinstituting kind of the types of protections that patent owners had as property rights owners. But because Musk has Trump's ear, and also there's a populist strain of thought in the Trump world, populism tends to view patents as these monopoly grants as well, then there's a concern that, it could go the other way. And that he could end up repeating some of the attacks that we've seen in the past 10 or 15 years, and we saw under the Biden administration on patents in both the technology space and in the biopharmaceutical space.
Gotcha. So let's talk a little bit about the global dynamics. How about we start with your sort of 101 on China's recent approach to intellectual property?
Right. So the two themes that a lot of people hear about China is, on the one hand, we hear a lot about how they steal our intellectual property. In fact, in the first Trump administration, this was a basis for him starting his trade war. In part was because he alleged, and rightly so, that China was engaging in billions of dollars of theft. In fact, the head of the FBI in congressional testimony has said that it's one of the largest wealth transfers in human history. The theft of the intellectual property assets by the Chinese government, the Chinese entities, hundreds and hundreds of billions of dollars, it's estimated to be. And so people hear that. But then they also hear sometimes in patent policy and in other discussions about how, well, China is also incredibly innovative, and they've developed their own very strong patent system, which they have. And so then the question has become well, which is it? Are they stealing our intellectual property because they're not innovative and they don't respect intellectual property rights? Or are they protecting intellectual property and they're incredibly innovative themselves? And so, because they sound on the surface like they contradict each other. And the answer is they're both. Because for the Chinese Communist Party, they have adopted both policies as part of kind of a geopolitical strategy and as a domestic industrial policy growth strategy. They want to grow their economy and become a superpower. Well, how do you do that? Well, you could do that. You do that through two ways. One is You promote your own citizens to become innovators and inventors, and you promote economic growth internally and domestically. And you do that by having a strong patent system that ensures that innovators are protected and they can license and sell their new innovations in a market, and that they can recoup their investments, and that they can enforce their rights when they're taken from them, like any other property right owner. And then when you don't have technologies, you steal them. And you take them from other people, other countries. So it very much is an integrated approach that they have. It's the first time this kind of approach has been really taken in any meaningful way in this way, which is, I think, why it's so confusing to people.
Well, I do think there's like this interesting, we're going to bring it back to the 18th century, like the fun sort of incentives that both the UK had in trying to get inventors, industrialists from Europe to bring their inventions, as well as what the US did to try to sort of like lure manufacturers or engineers over from the old world, I think are really interesting. You can probably tie this together better than me, but how are some of those practices being replicated today?
Well, so some people say, yeah, well, China's just doing what the United States did, because some people claim the United States lured British inventors and other people to take technologies. One example that's often used is there was some industrial espionage by an American citizen of loom technology for making shirts and things like that, in the 1790s. As an example of this. And they say, see, and England did it too, because England used their patent system as these monopoly grants to lure people away from Italy and the continent to come to England, which was actually really true. Patents were originally this kind of royal monopoly grant that they offered as a way to promote industrial economic development in the realm of England, in the 16 and 1700s. By luring inventors from Italy and the continent to come to England to set up their manufactures and their arts in England to develop the English economy. So it all sounds like, well, China is just doing what England did and what the United States then did. So what's wrong with what China is doing? Well, because what the United States actually never did officially what England did and what China did. The United States actually did not have an official policy of intellectual property theft. It was not part of the United States law or regulations, and you will search in vain for this. There are individuals who chose to engage in industrial espionage, but they were not reflective of American policy, the U.S. government policy. And in fact, the United States was one of the very first countries to recognize that foreign inventors had as much of a right to obtain patents as inventors under U.S. law as U.S. inventors, that they were on 100% equal par with each other. So the United States took very seriously the idea that these are property rights, and it doesn't matter if you come from England or if you invent in France, you can get a patent here in the United States under the same terms and the same protections as U.S. inventors. It does. So it's great that you asked this question, because there's a lot of confusion about this. There's a lot of claims that but this is how the United States developed itself. And it's actually not true. It's actually not true that there was a policy of the U.S. government to do this. Individuals may have engaged in industrial espionage because that's happened through human history. Individuals do this all the time. But this integrated policy of the use of patents as an economic domestic industrial policy or development device, which is what England is and what China is kind of doing now, is different from what the United States has done for the past 220 years.
Gotcha. Well, let's take this now to sort of standard essential patents and the fight over licensing. So, you can't really credibly just totally steal your way into that. But there are sort of levers that China and the EU have been trying to pull over recent years to try to impact the way that those sort of negotiations play out. How have those two bodies, tried to get their way on those issues?
Yeah, so it's very interesting. So almost all of the technologies that have been created and are being deployed and are driving the mobile revolution. So you know what you refer to as standard essential patents, right? Patents on the standardized technologies like 4G, 5G, Wi-Fi, and all the other types of technologies that underlay our amazing computer devices. Um, are were invented in the West primarily. And in fact, mobile technologies, the mobile telecommunications technologies, it's Qualcomm and InterDigital and Nokia and Ericsson are the primary people who've developed these technologies. Um,
Well, Huawei too. I mean, look, they're getting a big chunk of the next round,
they're
right?
getting them now, but they didn't invent them back in and
Sure,
Huawei didn't invent
sure.
them in the 1990s. So the foundation of the mobile revolution really is these companies. They are contributing now, and they are now classified, and they're now included as one of the five leading contributors to 6Gs and a little bit to 5G. But still, when you control for the actual patents that are of value to the standard development organizations, and not just the patents that are being filed and declared, the most of the patents are still coming from the Western innovators, and in fact, the royalty flows still are primarily to the West. I just published a white paper at the Hudson Institute on this that almost all of the royalty flows on mobile technologies and patents that cover them almost all go from Asia to the United States into Europe, not the other way
Mm.
around. So China's interest is still primarily from the perspective of implementers. So, Huawei's handsets, Xiaomi, HTC, others. So their interests are to depress as much as possible these royalty rates because to them, that's a cost to their companies. And by companies, I'm only using that term loosely because Huawei and HTC and Xiaomi, I mean, while they look and act and sound like companies, they're not companies in the sense that IBM or Qualcomm or Apple is in the United States. I mean, China is a communist country. I mean, if Xi calls up Huawei and says, "I want you to do X," Huawei does X. I mean, if you don't do it, you get disappeared for a while. I mean, we really need to be honest about this. I mean, and upfront about this. So they use, their court systems to advance the CCP's domestic policy agenda. And their domestic policy agenda is protect our companies and make our companies better off relative to foreign competitors from the West. And so they're using their court processes to artificially depress royalty rates, and to
I mean,
try to impose kind of lower royalty rates worldwide, through on kind of the Western innovators and European innovators.
so like I hear you, Adam, but like it's also a normal thing for governments to want their companies to flourish and succeed, relative to companies they might be paying for licensing abroad. So, given that that's the case, like maybe like what are the specific kind of legal strategies that the Chinese and Europeans are pushing, and how has and hasn't the U.S. government responded to those arguments?
So, I mean, I would challenge the normative implication of your premise because as a descriptive matter, what China is doing, any country can do. The question is, should they do it? Because the United States doesn't do it. The United States doesn't, in its court system, treat a plaintiff from England or France or even China differently than it does a plaintiff from the United States. That's what's called the rule of law, and the rule of law is foundational to equal treatment of people, regardless of their national identities, regardless of their citizenship, and the rule of law is and a key feature of what's made our patent system in the United States function so successfully, and in the West succeed so brilliantly, is because you can't have successful markets and successful societies without the rule of law. And so it's a foundational violation of the rule of law to say, well, if you're a plaintiff from America, we're gonna pretend that you're getting a valid court hearing and valid court processes. But at the end of the day, this is just a bureaucratic, Communist Party apparatchik institution, and we're just going to impose on you whatever we wish to do. That's not the rule of law, and that is a problem. And and we don't do that. We don't. If a Chinese citizen has rights that are violated in the United States, we don't say, well, you can't file a lawsuit, and you're going to get different types of damages than an American citizen and things of this sort. So I'm saying, I challenge the premise a little bit. Like you're like,
Sure.
Well, of course countries do this. Really?
So what's the pitch to your median Chinese government official that, in fact, buying the Adam Mossoff worldview of the benefit of patents would actually rebound positively to China and its companies and its future growth trajectory?
Well, the pitch is that it's not true that just having a patent system means innovation and growth. I mean, and this is what economists have all recognized, that historians and economists widely recognize and agree that patents are key elements, key features to very successful innovation economies and to economic growth of societies. But they're a key feature, but not the only one. It's patent systems that are within a country governed by the rule of law with stable political and legal institutions that function properly as legal institutions as distinct from political institutions. This is what made the United States patent system succeed. We broke from England and started to define patents not as these arbitrary grants from the crown that were really difficult to get, that were limited to aristocrats, but that they were accessible and usable by anyone who met the legal requirements for obtaining a patent. They were enforceable in court. Didn't matter who you were, what your economic status was, what your national background was, what your heritage was, your sex. Women could get patents just as much as men. It was truly a rule of law type system governed by stable political and legal institutions. And so that's what China has to recognize, is that they can't just, build a patent system and say, okay, this is going to be the key to success, because if they're still manipulating it through political policies like domestic industrial policy, in treating different patent owners differently, whether you're foreign or domestic and things of this sort, then you're undermining the very reasons for why you have a patent system and why you should have a successful country in the first place.
So what leverage, if any, does the U.S. government have in sort of like influencing the way that these the way that these legal proceedings and ultimately commercial negotiations play out in both the EU and Chinese contexts?
Okay, so there's two things that the U.S. government can do. So first, domestically, right? We need to reestablish the reliable and effective patent rights that we used to have in this country. Patents as property rights backed by presumptions of injunctions for infringements, which is what existed for 200 years, as drivers of innovation economy, effective licensing, the effective ability to get patents on proper inventions and things of this sort, because China and other countries would quote back to our own officials when we would complain to them that, like, well, you're doing some of the same things to your own patent owners, so why are you complaining to us? So we have abdicated what used to be referred to as our gold standard patent system to other countries, and we need to reclaim that moral, legal, and economic high ground by saying we are going to protect innovators in this country again the way we historically have. Thomas Edison, Alexander Graham Bell, the Wright brothers, these were people who were made possible by the types of patent protections that we provided, and we need to have those patent protections again. That will then drive people to once again file lawsuits in the United States. The licensing activity will occur in the United States, and we will become a leader again in these areas. And we'll be setting the terms through our system of law and through the rule of law that governs our courts and our institutions. So I think that's really the most important thing we can do. That's the thing that we have the most control over, and that's the thing we should care about. Then the other way that the U.S. can address it is a bit more difficult, because that's kind of the international realm. Like, because you can't just get another country to agree with you to do what you want to do if they don't want to do it, right? So at the end of the day, China can just thumb its nose at us and say, we're not going to do what you want us to do. And that's what Trump addressed in his first administration with the trade war and other types of sanctions that they started to impose upon China. I don't personally think that there should be sanctions. I think that and trade wars and tariffs, because those are economically self-destructive over the long run. But if they are stealing our intellectual property, that's destructive. And if we won't stop, we have a very limited tool set of what we can do internationally to force them to try to respect the rights of our citizens. And one of these is, one of those is through isolation, economic and political isolation, which we may have to do if as a leverage point to get them to respect those rights. But other than that, the most important thing we can do is focus on what we do have control over and what our government does have responsibility for, which is protecting the rights of U.S. innovators and ensuring that those rights are protected domestically to the best that they can be, such that we are then a leader again in this space, both legally and economically.
Adam Mossoff, thank you so much for being a part of ChinaTalk.
Well, thank you, Jordan, for having me on. This was a fantastic discussion. I really enjoyed it.
Likewise.